Thank you very much, the organizers of this meeting, and particularly Dr. Chauhan, for inviting me to this very important conference. Today, I want to talk to you about reservations, and in particular, reservations for the transgender community. I think it's important to begin with the constitutional philosophy that we have actually uh, imbibed, and that constitutional philosophy is in the preamble. And I think it's important to actually read out the preamble because it has enormous significance in terms of reservation, equality, and marginalization, which is what we are talking about. And it says, the preamble, that is, we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens, and this is important, justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship. Very importantly, equality of status and opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. So we, the people of India, actually enacted this Constitution and gave it to ourselves. And the most important thing, in my opinion, which is relevant for our meeting today, is the notion of justice, equality, and equality of status and opportunity. Now, even in international law, equality is an overarching right, meaning it cannot be derogated from. You can take other rights, like, for example, freedom of speech. You can actually restrict freedom of speech at in particular circumstances, as in our constitution, on the basis of what are known as reasonable restrictions. But equality is one right which cannot be derogated from. But what is the meaning of equality? Because in all countries, and in particularly India, when we actually adopted this constitution, there was a sea of inequality. And the inequalities range from on the issues of caste. Our society has been divided for centuries amongst the Hindus on the basis of caste. And that's a very important factor that was to be taken into consideration when the constitution is framed. Not only on equality of caste, but also inequality on the account of gender. And gender doesn't mean only biological gender. It also means what is called perceived gender. So that's where the transgender issue comes in. But in that sea of equality, if you just say that there should be equality of status and opportunity, does it mean that equality is actually achieved? No. And that is the difference between what is known as formal equality, that is, you actually say there will be equality of opportunity and status, and what is known as substantive equality, where you actually try to achieve equality between the people who are governed by their constitution. So our constitution's approach has been to have what is known as substantive equality. So it is not only against protection against negative discrimination, because Article 15, 14, 15, 16 form a triage, and 15 talks about discrimination on particular grounds. But only if you have formal equality and not substantive equality, then you will not actually achieve it. So there has to be what is known as protective discrimination or positive discrimination to achieve equality. And that is what our constitution seeks to achieve through Article 16. Now, 16 is important in terms of matters of public employment. Because caste was such a barrier, the constitution actually engrafted very important provisions, and particularly for our relevance, 16.4 and 16.4a, it actually allowed the state by an enabling provision to make any provisions for reservations of appointments or posts in favor of backward classes of citizens, which in the opinion of the state were not adequately represented. Now, importantly, what is the purpose of it? The purpose is the state actually has the power The power is controlled by a minority elite, and the objective of the provisions of the Constitution 14, 15, and 16 is to achieve equality of representations in the echelons of power, that is the state. So if you don't have proper representation according to your numerical strength, then you will always be governed by a minority elite. And 16.4a also talks of enabling the state to have protective discrimination and reservations of posts for the communities of scheduled tribes and scheduled castes. So you have other backward classes, scheduled tribes, and scheduled castes. Now, and this is, I think it is important here to stress that it was Dr. Ambedkar's philosophical underpinnings that unless you have reservations, you will never be able to achieve substantive equality. If formal equality only ruled, then reservations will not. Then the objective of equality, my apologies, will not be achieved. That is equality of status and opportunity. So, in an unequal society where there are historically oppressed groups, it is important to provide reservation, and that is the only way to achieve equality of status and opportunity in the long run. And this is emphasized by the Supreme Court also when in Indra Sawhney they said that the objective of Article 16 was the sharing of power in the state, because otherwise it will be exclusively monopolized by very few communities, namely the upper caste. And the objective is to have sharing which is broad based. And the objective is, in fact, to have all communities represented. And that is what is known as plurality. We are actually governed by a constitution which emphasizes plurality, whether it is on account of religion, caste, gender, etc., ethnic origin, etc. So all communities, whichever religion they belong to, whichever the caste they belong to, whichever gender they belong to, whichever ethnic community they belong to, should be represented in state power. That is the only way you will actually get equality. For that, in our constitutional understanding, the way to do is through reservations. Now, in this context, I want to emphasize to you that the transgender community is also a community which has been historically oppressed, and therefore it was thought fit that somehow transgender community should be represented. Now let me just go back a while and just talk about what transgender community is all about. Now, historically in India, ancient India from 300 to 700 AD, the concept of the third gender was highly prevalent. So neither a man nor a woman. For example, the Hijra community. The Hijra community is actually men who are castrated. So they're not a man because they have no penis. Similarly, because they don't have a menstrual cycle, they are not a woman. So neither they are a man nor are they a woman. That is why in the ancient Indian texts, whether they were Brahminical, Buddhist or Jain, the concept of the third sex was quite prevalent. Tritiya Prakriti is third nature, and that is part of our Vedic and Puranic literature. Now, unlike say the Buddhist and Hindu texts, which talked about the third nature, third gender, or what we call transgender now, that was based on the biological understanding of sex. But in Jain texts, very interestingly, the concept of sex was psychological, beyond the primary and secondary physical characteristics. And even later on in the medieval India from 11 to 1800 AD, that is during the Mughal period as it were, there is very important notion of actually respecting the Hijra community. Hijra community occupied prominent positions as political advisors, administrators, generals, as well as guardians of harems. Only the latter is known. But they also held important posts in Islamic states, even in Makkah and Medina. And basically, in all these historical eras, gender was not seen as a binary concept. Gender was seen as a concept which is either biological or psychological, but it was not restricted to the male and sex, but it went beyond that. And this has been documented in a very important book by Sarina Nanda, which was used by me in the Supreme Court in arguing the Nalsa case. Now, historically, it is only when the British established formal rule in India after we lost the first war of independence, and they established formal rule, they established laws, and particularly the Indian Penal Code and the Criminal Tribes Act, that you started in India to see that these third gender hijras were being criminalized, because 377 talked about unnatural sex, and it basically criminalized sex between what you call so-called unnatural, which is penile non-vaginal, between men and transgender persons, men and animals, etc. So the very core sexual being of a hijra was being criminalized by 377, as also for gay men. But also hijras were subject to criminality because of the Criminal Tribes Act. So the British were the people who actually criminalized, not only because of behavior, but because of what tribe or community you belong to. That lasted from 1860 to basically this century. It is only after, in 2009, when we mounted a challenge to 377 in the Nas Foundation case, and ultimately we succeeded in the Delhi High Court in 2009, and afterwards in Navtej Johar in 2018. Now, in between that, the issue of transgender people had come in, and the Nalsa judgment was pronounced. The Nalsa judgment actually understood that there is something like the third gender, and it recognized it in terms of law, and also prescribed that transgender persons should also be allowed to have posts reserved for them. But unfortunately, according to me, the reservations were actually given to the transgender community in the other backward classes. This, in my opinion, there's an error in this. There should have been reservation not only in OBCs but also in other groups. So, because all transgenders are not OBCs, if there is only reservation in OBC and a person by virtue of that person being a transgender gets reservation in the OBC category, then the person who is not OBC is getting a reservation in OBC, which is not fair to the OBC community. So what is required is to have what is known as horizontal reservation. So if a transgender person belongs to the scheduled tribe, that person will get a portion of reservation in the scheduled tribe quota. Similarly in the scheduled caste quota, similarly in the OBC quota, and now because we have EWC, economically weaker section, EWS, there the reservation would be for the general category. So you can have a prescribed portion of reservation throughout these categories. But of course, it cannot be done on the basis of one time this thing, it will be on the basis of roster. So in my opinion, we have to actually sensitize ourselves, sensitize the community, sensitize people in government that reservation is necessary also for transgenders so that they actually get equal representation in state power. And the way to go about it after NALSA is not only for reservation in the OBC category, but also in all categories, scheduled tribe, scheduled caste, OBC, and the EWS. Thank you very much. I hope this has been useful. As a final conclusion, that we as lawyers have to actually propagate the constitutional philosophy, which is in the preamble, and particularly equality of opportunity and status for all marginalized sections. I hope you as lawyers will actually propagate that. Thank you very much.
MNT न्यूज नेटवर्क को सब्सक्राइब करें, लाइक और फॉलो करना ना भूलें। साथ ही बेल आइकॉन दबाकर जन जागृति की मुहिम में जुड़े रहें।